Hello.
Hello. Now we don't have Chris to be like, hello, Yella. Now we have to wing it. How are you, Bruno?
I'm very well, thanks. How are you? So
I'm
maybe just
very
to
well, thanks.
explain, to everyone, Chris isn't here because he's doing a conference. So I think he got very popular, and now people want him on their shows. But sorry, Selma, you were saying you well.
Well, we like to believe that at least our webinars had a hand in his popularity, because let's be fair, he is the best host ever. So, Chris, have fun, man. But now you're leaving the kids alone without
Yeah.
any adult supervision. So I'm a little worried about, especially because we need to get through all the questions that our viewers have been waiting for since, some of them, December, for answers. So I hope we're going to
Especially
be good.
considering that we haven't read the questions, we haven't prepared for them. So this is the first time that we're going to be addressing them. So yeah, we need a host. We desperately need a host.
We really need a host next week. I'm sure we're going to have a host, but at least our viewers know we are, some of the few attorneys that are very, I'm not saying few attorneys, there's a lot of attorneys like this, that's actually truthful and saying we haven't read the question. So this is going to be amazing. Bruno, how are we going to do this? Am I asking you a question?
I think we need to start with the disclaimer first, that since we haven't read the questions, like, don't hold us to this. This is not legal advice. It is more guidance. Like, please seek help from a professional if you need a proper answer. All right.
I love that disclaimer. Shouldn't we have that disclaimer always on our page?
Yeah, we really should. We actually should.
We are professional.
Yeah.
But not when we have to do quick fire questions, but we'll be as professional as we can be without a host. Let's do that. Okay, who's starting?
I'm happy to start.
Okay, hit me.
Okay, cool. So question number 1 is from Mark. Mark asks, tenant moved in and gets mugged outside and car was broken into within hours. I think we actually did answer something very similar to this a couple of weeks ago. Now he gave CPA notice and will move out on day 2. It's a 11.5-month lease. What is a reasonable cancellation penalty? We will remarket it at the same rent ASAP, of course, to mitigate losses, but it had taken a very long time to find the tenant, so I fear it will be vacant for a long time. The price is not too high.
Oh, yay, that's a nice question. I'm so happy I got it. Thank you, Bruno. Okay, but this is my professional legal advice on this one. So Bruno's disclaimer doesn't count for this answer. This is the actual answer. So section 14 of the CPA, you know I'm going to do that the whole time, right? Section 14 of the CPA allows the tenant to cancel the lease agreement, but he has to give 20 business days notice of such cancellation for that provision to apply to the particular cancellation. So in a case where the tenant gives notice today and just leaves, the CPA has no bearing on that, and your full damages that the landlord suffered will be payable by the tenant. If in a case where the tenant did actually follow the correct process and he gave 20 business days notice, he will still be responsible to pay the landlord a reasonable cancellation penalty, which is recorded in most lease agreements as, say, 2 or 3 months rent. And if the landlord can mitigate damages, so he can place a tenant earlier, then the tenant would not be responsible for the full cancellation penalty, but only for the actual damages that the landlord suffered, and that's in terms of the Conventional Penalties Act. You can't claim a penalty more than what your actual damages would be. So in this case, the fact that the tenant got mugged and there was a break-in in his car, unfortunately, doesn't change any of the facts and any of the answers I just gave. It's unfortunate, but the truth is we live in the world, there's crime everywhere, and a landlord is not responsible for a tenant's safety. Obviously, a landlord's responsible to ensure that there's a roof and a door, which should provide that security. But a landlord doesn't have to be, doesn't have to cater for the tenant's security. So unfortunately, in a case like this, I can't say what the reasonable cancellation penalty would be. From what I'm reading, the tenant didn't give the 20 business days notice. So it's not a reasonable cancellation penalty referred to in terms of Section 14 that this particular tenant would be, landlord would be able to claim. This landlord would be able to claim the actual damages that he suffered as a result of this early cancellation that was not done in terms of Section 14 of the CPA. Lekker. Are you happy?
Yes.
Thank you. Are you ready? Okay,
Yes.
Yella. It's because I have to read now. I think this is one of the few times I actually wear my glasses on the webinar. Alrighty. This is from Sita. Hello. 5 individuals pooled cash to buy an RDP house with no consent from human settlements and no title deed. However, a deed of sale was signed between the seller and the buyers with a lawyer. What is wrong with such sale? Wait, there's more. Is there any risk in this arrangement? I see people saying they bought RDP houses with no title deed, where no title deed exists, saying that they went through lawyers, which they were furnished with a deed of sale by the lawyer and paid 1,200 rand. How legitimate are these transactions?
Sure.
I am all ears.
Wow. Okay. So let's start right at the top, right? Just because there's a purported lawyer involved doesn't make it legitimate. If there is a lawyer involved, or this person claims to be a lawyer and have law offices, please contact the LPC, previously known as the Law Society, and just confirm with them that the person is in fact a practitioner that hasn't been struck off the roll, that is allowed to be trading. Reason for this is because the advice that this lawyer gives you is obviously part of the professional scope. And there are insurances in place that if a lawyer gives you bad advice, that you can actually claim against them from the Fidelity Fund or from professional indemnity insurance. So this is more just kind of a backup plan. It's not to say that because he's registered as a lawyer, then it's 100%, but at least it gives you that kind of coverage where, if this person's not registered, then escape, run away as fast as you can, right? So that's number one, the lawyer aspect, right? So let's take the lawyer aspect out of this, because we're all assuming that this person is giving good advice, but this sounds very strange to me. So first of all, you don't buy land without a title deed. Simple as that. Land in our law in South Africa is registrable land. Yes, there is non-registrable land, but not like this, especially not RDP houses. RDP houses are built to be registered. They're supposed to be giving back and giving people housing. So people buy these. And you need the consent from government in order to be able to obtain these. And there are certain limitations on what you can do with these properties. So a number of years after you initially purchased the property, last time I checked, about 8 years, you're not allowed to dispose or alienate of this property, give it to anyone else. Why? Because this is there to cover housing. So this isn't for property investors to go out, get housing from government, and then go try rent it out or sell it or flip it to people so they can make an extra buck. This is for housing. That's the purpose. So this limitation is there, so it's at least it stays in your name and your family has somewhere to stay. And yes, after a reasonable period of time, you're able to actually sell, right? So now this comes to the second point, is we don't know whether this period of time has actually lapsed or not. But this property should have a title deed. So the reality is that you should be able to find this title deed in the deeds office. You should be able to verify the period of time in order to figure out whether you can actually buy this property or not. I'm already getting taken aback, or I'm already very apprehensive with the notion that there is no title deed, because there has to be a title deed, right? A deed of sale is not proof that you're owner of a property. A deed of sale is a contract that entitles you to enforce transfer. But I've been involved in transactions like this. And what I find is, number one, people don't realize they're not allowed to sell the RDP house. So they sell it anyway. And then the deal can't go through. Or you're buying from someone who potentially bought from somebody else, who was never entitled to buy it to begin with. So this thing's being on-sold over and over, no title deeds in place, simply because the person you're buying from isn't actually the owner of the property. So you need to make 100% sure there is a title deed, there is a deeds office, get a hold of that, double check what the terms are, double check who the owner is, and then, yeah, so go to a reputable attorney. Yes, you might need to pay for the service, because if they're not doing the conveyancing, and I mean, this might not even lead to conveyancing, there's a bit of due diligence, but it makes more sense to do it properly. And I mean, I saw over here, it was 1,200 that was being paid. For 1,200, I mean, the due diligence could probably be done. It's a matter of sending someone to the deeds office and pulling a title deed. So 1,200 would actually probably cover a very basic due diligence. And then just the last thing that's worth mentioning, 5 people buying one property, like, guys, be careful. That's a big one as well. You know, just make sure that in between with each other, you know, the systems are in order. You guys know why you're buying it together. You guys have it in the correct structures, because I mean, you buy this and one person dies and there's an issue and the bank wants to recoup the money, or each of you are paying to the bank and one person doesn't pay. What happens then? You do need to address that as well. So just as a side note, that's also a big red flag for me.
That was lovely. Thank you, Bruno. I was also concerned. I was like, something doesn't sound right. But you were very diplomatic. I'm glad you got the diplomatic question.
Nice. Yeah. And my disclaimer doesn't apply to that one as well. So we're good. All right. Third question. Now, this is for Silna. I need advice, please. I'm in the process of buying a house. Now I received the OTP to sign. Do I sign the OTP with blank spaces?
No, never.
That's
the answer. Let me explain very quickly. I actually say there's sort of two that wants to have a baby. The second question is from the same viewer.
Sure. So, morning all, can I ask if the bank is selling that one?
Yeah.
Okay. Can I ask if the bank is selling the house, can I go straight to the bank and buy it if I have cash, or should I buy through an agent?
Brilliant. So that's why I wanted both. Thanks, Bruno.
Sure.
And why I wanted both is I do want to jump back to the signing an OTP with blank spaces. An offer to purchase, a deed of sale, call it what you want, a sales contract, whatever name you want to give a contract, where one person is buying an immovable property from another person. In terms of our law, that contract has to be in writing. Now we have fun rules around contracts and what they should comply with. First rule of law of contract, and I think everybody knows this. I think this is one of those things that not only lawyers know. This is one of those things everybody knows. If the parties haven't reached consensus, and consensus, the base definition is meeting of minds. If the parties didn't see, oh yes, this is my obligations, this is my rights, this is your obligations, this is your rights, and we cool with that. If that did not happen, you do not have a valid contract. It's usually not voidable. It's in most instances, when you haven't reached consensus, it's void ab initio. It never happened. Like, you couldn't have a contract if there are things that the parties did not agree to. So a contract with blank spaces scares the living daylights out of it. Personally, I will never draft a contract with anything that has to be completed in the body of the contract. So I always draft with a schedule, with a schedule in the beginning, and then cross-reference in your terms and conditions, for the simple reason that you can't really miss something if it's in a schedule. Because if you miss something and you have blank spaces in your offer to purchase, depending on what is left blank, it could affect the validity of the contract. Let's say, for instance, the purchase price was left open, or the way the purchase price must be paid. Are you getting a bond? Are you paying a deposit? Whatever the case might be. If that is open, if that is left blank, I can't see that you've reached consensus And that contract, depending, like I said, on what it is, could be void or voidable. So never sign a contract with a blank space. If you forgot, if you signed a contract with stuff to complete through the body of the agreement, and you accidentally forgot to complete your email address in the notices clause, not a crisis. Does not affect the validity of the contract because it doesn't change the consensus that the parties reach. It could end with ambiguity, and ambiguity, unless it is excluded from in terms of your interpretation clause, you could have a problem where you are the party responsible for drafting the contract, that if there is ambiguity in the contract has to be interpreted against you. So you could have that risk, but that's not the worst thing. So it depends on what's left blank. But personally, especially as the purchaser, I will never, ever, okay, actually also as the seller, I will never sign a contract with blank spaces, because you might have agreed telephonically that the purchase price would be 1.5 million rand. You get this contract, the seller says, "Nee man, moenie worry nie, I will complete it for you. I'm going to save you some time." And they complete it with 1.8. And now we end up with a rule in law of contract, the extrinsic evidence rule, which is if you have a contract that is in writing, you are not allowed to bring any evidence outside of that contract. So if you signed a contract with a blank space, to try and convince the court that that was in fact not what you've agreed to, is not really going to happen. So the second question that relates to this is the bank question. If the bank's selling properties, you have cash, can you buy it from direct, or should you work through an agent? Same, and that's why I'm saying it relates to all of this. I do like to work through an agent. Property practitioners, as of yesterday, we don't have estate agents in South Africa anymore. They are now, as of yesterday, property practitioners. So if you work through a property practitioner, I can promise you your chances of having a good quality contract, your chances of making mistakes like blank spaces is it's much less. However, most of the banks doesn't necessarily use estate agents. They might make it available through their website or another auction site or something. So if it is available where you don't need to use a property practitioner, you don't have to. You are allowed to contact the bank directly, but make sure, again, you have a proper agreement to back your purchase there. Sure.
Nice. So just on top of that, buying properties. So remember, by the time it gets handed over to an estate agent from the bank, chances are the bank isn't dealing with it directly. Mandates have been signed, so most of these agents have secured the fact that purchasers aren't going to bypass them and try and escape the payment of collection commission. So as soon as I start hearing this question, it's already a bit of a worry, because it's always about agents' commission. And yeah, this is when claims for agent commission kind of kick in and people start getting sued for commission for having bypassed them. If you've spoken to the agent, he's taken your number down, and you go directly to the bank, and it happens that the bank's willing to sell it to you directly, and the agent finds out about it, they'd come after you.
Double commission.
Yeah.
Lekker, are you ready for your question?
I am.
Okay, so this question is from one of our very regular viewers, sharers, everything is what does Facebook call these people? Super fans. So Johan Otto, one of our super fans, and we appreciate you.
Influencer, but cool.
Johan is a super fan, influencer, everything. Cool. So Johan, this one is for you. I'm sorry we made you wait about 2 months to answer.
Oh, wow.
And so his question relates to spoliation orders. Bruno, from context, it does feel like we're talking tribunal. So here it is. A client, Mr. Jacobs, asked, how does a spoliation order work? Just got an SMS to say it was approved, which is why I'm guessing tribunal.
Yeah, tribunal.
But not sure how do I go into the offices again, or where do I get it from? Or where do I go from here? Also, what happens if the landlord doesn't abide by the spoliation order? Lekker.
Okay, nice. Okay, no, 100%. So look, spoliations in general, even if we move away from a distinction between match court and the tribunal, spoliation orders in general, they're granted and enforced by the sheriff of the court. It's as simple as that. So why would someone get a spoliation order? Typically, spoliation orders are granted if you lose possession of something that you had in your possession, and you go to court to express that it was taken out of your possession. Also bearing in mind that the right that you had to possess is inconsequential. You're just speaking about having undisturbed possession and somebody unlawfully depriving you of it, right? So once that act takes place, you're able to go to court and ask the court for an order, just restoring the status quo until the rights can actually be resolved. So that's the basic history of spoliation. So whether you go into the tribunal or a magistrate's court, an order or an award would be made, and this award, normally you'd serve it on the person that you got the order against. So this, for example, the assumption is that it's a tenant, and the landowner or the landlord is the person that dispossessed them. So the tenant would get this order, and normally you'd serve it first on the landlord to say, listen, I got an order against you, give me my things back. If that doesn't work, which very often you find that it doesn't, the sheriff accompanies you there, and you go with the sheriff, and whatever was dispossessed gets restored. And in the context of property, this would probably be the opening of a door, or like removing of a lock, or whatever the case is. And so now so that works side by side. So the tribunal, an order of the tribunal has the same effect as a magistrate's court order. So pretty much the same way that you'd enforce a magistrate's court order is the way that you'd enforce an award from the tribunal. As of late, especially due to the Disaster Management Act, the tribunal is now entitled to make these orders for spoliation, because it is a criminal offense to basically perform an act of spoliation. So now people have two options. They can go to one or the other. They can get the awards, and they can approach the sheriff for execution. Does that cover everything?
It does. It does. And I love the fact that you use the term awards, which is absolutely correct when it comes to tribunal orders. And I think there's a lot of people that does enjoy receiving awards. So, hi, Yella. See, I have to stand in for Chris's jokes if he's not here.
Okay, so now it's my turn. I think there's 2 questions mixed up in 6, so we might actually have 9 questions today. So let me do question 6 up until the halfway mark, and then there's another one.
Thank goodness, because the second question is totally you answer. So just hit me with Natasha's question, I'll hit you with Ryan's.
Nice. All right, so property is registered in 2 names. When they sell the bonds, the bonds get paid and money are divided in half. What happens when one person passes away before the sale is completed, still waiting for bond approval? And what happens if it happens after the sale, but before the property is registered in the purchaser's name?
Who is passing away? Seller.
I think the seller is passing away. So they own the property, they sell it.
Yes.
The purchaser is applying for a bond. What happens when one of them, the sellers, pass away before?
I see. Bond approval and after.
Bond approval and after bond approval.
Yeah. Okay, cool. I've got it. Natasha. Luckily, the bond approval in this context isn't going to change my answer. For the simple reason, the only difference here on bond approval or not would be obviously if it's a suspensive condition. If the suspensive condition is not fulfilled, so the bond is not approved, and accordingly the suspensive condition kicks in and it's like there was never a contract, it's pretty much nothing, because the property will still vest in the deceased estate. So remember, you have an undivided share in a property. So the deceased if he then passed away prior to fulfillment of the suspensive conditions, so prior to bond approval, it would just be as if people are joint owners and one of them passed away and they're not planning to sell. So that's what that effect would be. They're not going to sell. So then how we deal with the money is going to be irrelevant at that stage. But either way, if the property gets sold and one of the owners are deceased, whether prior to conclusion of the contract or thereafter, if he passed away prior to contract fulfillment of suspensive conditions, prior to conclusion of the contract, this contract would not be done by the deceased because the deceased would be deceased, and it would have to be done by the executor of the deceased's estate, unless this property was owned not by natural persons but by juristic entities, and one of the two owners of the property or shareholders or whatever has got resolution from the other party to act on his behalf, even if he passed away. In a case like that, it's fine, and you can conclude an agreement. What happens to the money is, once again, whether the seller passes away prior to or during the transfer process, the proceeds must be paid out to the deceased estate. So obviously, once again, the executor would be appointed and would be paid over to the executor. If an executor is not appointed by the time that registration is finalized, most likely the conveyancer will keep the proceeds due to the deceased in their trust account until such a point that they receive letters of authority from the master's office approving this executor, showing that an account was in fact opened for this particular estate, and then the proceeds will be paid over to the executor to be handled in the finalization of the estate. Did I get everything there? You're on mute.
I think you did, yes.
Right. Are you ready for Ryan's? I think it's very much a you question.
Cool,
Good day. How long does a debtor have after sale of execution to salvage the property with full outstanding amount? If this is legally possible, can you please advise Rule 46 capital A, subsection 9, was handed down 17 January 2022.
Okay.
Go, Bruno.
Nice. So 46A deals with the sale of immovable properties through the High Court. Subsection 9, it was basically something that was introduced in order to make provision for reserve prices. Our sale and execution laws a couple of years back were still very open. Properties, the court had a discretion on how the sale was supposed to take place, but never was it necessary to actually have a reserve price set. Due to some abuses around certain jurisdictions, the rules came out with a provision requiring now the courts to approve a reserve price. All this effectively means is now if a bank wants to foreclose, in addition to the number of hurdles that they need to go through to sell the property, one further hurdle is that they need to do valuations, bring it to the court's attention, and ask for a reasonable price, ask the court to set a reasonable price, bearing in mind that because it's a forced sale, one normally doesn't expect to get full market value. So, you know, a typical rule of thumb is 100% less 20 or 30, right? On a side note, as a matter of opinion, this is causing quite a bit of backlog and a bottleneck, I found, because the courts don't know how to deal with the purchase prices. The valuations don't always take into account the difficulties that people might experience with particular properties, meaning that I've seen properties go back on auction 3-4 times. Constantly, the banks having to go back to the court, say, oh, well, it didn't work. Please approve. Please approve. I have seen recently a practice is to go to the court with the highest bidder, even if it was under reserve, and ask the court for leave, just to allow the sale to go ahead, and just to prove that this was the highest price attainable. It's not that bad. It would be justifiable to just let it go as opposed to having it placed on auction again. Anyway, so now going back, the tough part of this question is, how long does a debtor have to repay to basically repay and salvage the property? Now, the National Credit Act under 129 specifically speaks, has a specific clause that at any given point the debtor can go and settle the debt with costs, and thus the sale needs to be stopped, and nothing will happen after that. The interesting thing, and we actually did a court case about this about a year, 2 years back, but the client didn't go ahead with instructions. There was a level of ambiguity as to when exactly this tender could be made to salvage the property. So there is a case that that went into it, but referred to a different section, and basically said that if a person settles the debt at any point before transfer, it's perfectly fine. They can salvage the property. After transfer is too late. So, but I think that's acceptable. After transfer is too late. Any time before transfer is acceptable. But the court didn't actually address the particular section that I was working on, which in the execution context, especially when it comes to immovable property, where you have a sale and 3 months later you have a transfer, and that's what one needs to look at. So it's not as simple as, here's an asset, we sell and transfer it immediately by exchanging it. This takes a 3-month process, and this particular section that I was focusing on basically said that if the property is sold, irrespective of whether it's been transferred or not, the initial sale, if that's been dealt with, you shouldn't be able to settle, basically make the tender and salvage the property. So there's two schools of thought, but the predominant one, because that case came out, is that anytime before transfer, you've got the opportunity of covering the bank plus costs if you make that tender. The bank has to accept it and stop the transfer from going through. Incidentally, just as a point of interest, if anyone actually cares, there were a lot of investors.
Okay.
Nice, thank you. There were a lot of investors that are making use of this by approaching the debtors after the sale and execution, changing the offer, making a secondary offer, obviously taking into account things like evictions and rates and stuff. And then if they had a cash purchase, actually going to the bank and making that tender, thus negating the sale and execution. And that's where my case arose from, because it was my client on auction versus this guy after the auction making a tender to the bank, to like a cash tender to the bank.
That is interesting.
Yeah,
we should have this conversation over lunch, because there's quite a few elements to that, and I think we're going to bore our viewers, but it's actually a very interesting question, if that would be slightly contra boni mores or no. It's actually that's an interesting one.
It's the wording of the act which makes it a problem. So we were with SCs. That's why I have no issue saying this. SCs was going to go to the NCA. So our argument was that unfortunately the court erred in how it dealt with the previous case, because it made a finding based on a specific subsection that shouldn't have been applicable. It was actually another subsection that applied. And in that other subsection, my interpretation seems to be right, because they use specifically the word sale. And if you look at the rest of the act, they use different wording, implying that the act is distinguished between what a sale is and what an actual transfer or delivery is. But yeah, so that's the technical side. So
yeah, it's because it's an interesting one. I mean, if you look at the in my kids' words, the OG sale and execution case, YAFTA. I mean, YAFTA makes it clear up to the point of transfer, the owner's right is only limited, but he still has the right of ownership,
dominion,
but exactly, but a limited right of occupation of ownership. But if you are a bona fide purchaser at an auction, to now be a third party popping in from the side, that feel, I must say, but I'm Ubuntu Bobby, so I must say Ubuntu was.
The third party is the effect, but it's not the third party's rights that are being protected.
Yeah.
So it's the equivalent of your property going on auction, me coming to you and saying, Sil, I'll tell you what, I've got R1,000,000 for you. So here's R1,000,000. And money never changes hands. So we do things in terms of guarantees. So here's R1,000,000 in my bank account. I guarantee you I'll buy this property from you. All you're going to do is you're going to take this guarantee, you're going to reword it and say, oh, here's a guarantee from me tendering the R1,000,000 to the bank. So the third party has no rights in terms of the National Credit Act, sure. But if I'm giving money to the debtor, I'm giving him the ability to exercise rights against the bona fide purchaser who bought the property, who spent, and and my argument is there's a void, because what happens to that sale? The Act doesn't speak about the sale being cancelled or terminated or there being restitution. There's a huge kind of anomaly on what happens to the bona fide purchaser. The sale just disappears, like up and gone. Doesn't make sense.
It doesn't make sense. Oh, okay, but now this is a very interesting conversation. We can do this for the rest of the afternoon. Okay, hit me with a question, Maralda.
Okay, so Ryan from Juanita. If a tenant is harassing another tenant on your property, even after complaints from the tenant and warning from the landlord, the other tenants don't stop the harassment and it's getting physical, can a landlord ask them to vacate with immediate effect?
Probably not. It depends on how far the harassment goes. If it is a loud tenant, and if it's getting physical, is sort of somebody walked past the one on in the parking lot and shouldered him a little. It is in fact a criminal offense. That in its own is what's the crime I'm looking for? Assault. Thank you.
I was it must be something I don't know.
Look at us being property lawyers and not criminal guys. Assault. So assault is a very wide crime. Even if you spit on somebody, it does probably fulfill the elements of the crime of assault. And if your lease agreement does allow for a situation where the landlord can cancel the lease agreement with immediate effect, in a situation where the tenant is guilty of a crime or committing a crime or suspected of committing a crime, and there is a provision where this crime must be reported to the police, there is actually good prospects of cancelling that agreement with immediate effect. And why I'm saying good prospects and not sure out law is if somebody is cooking crystal meth in your kitchen, or if somebody is using the rental property as a brothel, or if they are actually assaulting the neighbors, if you cancel the agreement on that basis, the chances of them coming to court fighting the lease agreement cancellation is slim to none. But in terms of Section 14 of the CPA, in fact, you do need to give somebody 20 business days to remedy their breach. The reason why we make an exclusion on crimes is it could be a very risky situation. Say somebody is cooking meth or selling drugs from the property. You could be, as the landlord, potentially at risk, and you can't condone crimes, but we can't make crimes up and say, this is why I'm cancelling the agreement, because I don't like my tenant, so I am saying he's selling drugs. Meanwhile, back at the ranch, it's actually a Herbalife person. I'm sorry, respect to Herbalife people, but he's actually selling Herbalife, and it's not in fact the drugs that you're thinking it is. It's actually a bona fide sort of side hustle that this person is having. So be careful of that. I must say, in a situation like this, if it's in a body corporate, in a sectional title, I would ask for the body corporate's assistance in this by fining the tenant for this behavior. If it's not in a sectional title complex, I would call the police at the next incident. Get the police out to come and resolve the situation. Place the tenant on terms. Give him another 20 business days to get his stuff in order. And make sure that that letter of demand is actually done by a specialist rental firm. Because if you word it correctly, you could then at the next instance where this person gets harassing, that's a legal term, cancel the agreement with immediate effect. But be careful of immediate cancellation. If it is something that's serious enough to require immediate cancellation, you might get away with it. But don't cowboy this one. Rather pick up the phone, chat to Bruno's firm, my firm, and get the right answer on that, because the facts and the specific facts in this matter is more relevant than just a quick answer. Lekker, Bruno. I think we're on the last question. Are you ready?
Sure. It's a long one. It's the longest one.
Oh, just get the glasses. Well, luckily I did my vitality test yesterday, and turns out on my vitality age, I am in fact 3 years younger than what I am in real life, but the eyes clearly did not get that memo. Nice. Alrighty, so Tabang is the lucky winner of asking the last question for the day. Good evening, afternoon now. I need advice. I met with people last year who have a student accommodation, 100 rooms, and they were struggling to fill it with students. We discussed that I would find students for them and will go 60-40 on the rent. However, now that I have found someone who can fill the rooms, they say we never agreed. Thank goodness for the PPA now, Bruno. Yeah, this is why I'm such a fan. Now, then the client, then the client I found, we never spoke about how we are going to partner on the deal. Now they are using that against me. They are saying I made agreement with the owner of the building, not with them. They have signed partnerships for 10 years and they are hiding that for me. Can you assist? It sounds like it's a lease with, it's a sub-lease sort of thing, because it doesn't sound like the owner is this person. It sounds like there's another person.
Yeah, I'm just trying to get my head around the question. So student accommodation, 100 rooms. It sounds like he was mandated to find tenants. Mm-hmm. And I assume this mandate came from the owner.
It sounds like from the tenant, because he says they are saying I made agreement with owner of the building, not them. So it sounds like a tenant or a person that has the right to lease out these 100 rooms, so and they are then entitled to the rent.
Or a manager.
Yes.
He spoke to this person. They had an agreement, but now this person, this caretaker, is saying that the agreement wasn't actually with him, but he was possibly acting on behalf of the owner, so it's not his problem. Right?
Yes.
Okay, cool. So look, there's a lot to get one's head around, because there's different ways of looking at this. So, I mean, the simplest one is the fact that this is a leasing mandate. You were acting as an estate agent. Just because the caretaker wasn't the owner doesn't mean that he can't give you a mandate, because if he's authorized by the owner to act on behalf of the owner, he can mandate estate agents to find tenants. So that's allowable. You as an individual finding tenants, less so, because even under the previous act, the whole scope of leasing and being able to procure tenants, things like that, fell within the ambit of being an estate agent. So without a fidelity fund certificate, you wouldn't actually be able to enforce your right to commission. On top of that, a commission of 40% is remarkably high. So on a mandate perspective, you would really struggle to actually enforce this. But now I'm now putting on a different hat because I've seen clients approach it differently. So if I'm a property investor, I go look at properties and almost do a rent to rent. So Silna mentioned sublease. I've seen a lot of guys like, okay, you know what, tell you what, I'll enter into a lease agreement, but we're going to make it subject to me actually being able to fill the beds up. But it's still a sublease. So they will pay me X amount, 100%. I will then in turn pay you 60%. I keep 40. It's not a mandate. It's not an estate agent. It can be drafted as a lease agreement because you're taking some level of responsibility for everything. So that's another way of looking at it. If that's the case, then yeah, there you'd have a better claim. You might be able to enforce it unless it looks so fabricated that a court might consider it as a mandate and says, you know what, call it what you want to call it. You are acting as an estate agent. But we've got a lot of clients that do rent to rent. So they normally take on a bigger responsibility, and that's how they make their money. So building has 200 units. They go, I will take 100 off your hands, but I only want to pay 60% of the rental, but at least 60% guaranteed. Are you happy? And they go, absolutely. I'd rather have 60% than zero. And then you go out and find creative ways of getting from that 60 to 100. So right, two things. One's like a sublet, one is a mandate. So I think I kind of covered both of those. Then the client I found, we never spoke about how we are going to partner on the deal. So that's with the caretaker. Now they are using that against me. They are saying I made the agreement with the owner of the building, not them. They have signed partnerships for 10 years and are hiding that from me. Can you assist? So sorry, there, I don't know, Silna, those last 3 lines.
I think you actually covered it, Bruno, because I think in your 2 scenarios, either you're acting on behalf of another person, meaning that you are a property practitioner, or under the Estate Agency Affairs Act, an estate agent, and without a Fidelity Fund certificate, you would not be entitled to your commission.
Yeah.
I think that, but I think this whole thing of they are saying, but he contracted with the owner, I think you covered it, and I think the answer is simply, guys, this is why we always say, when you do joint venture agreements, when you do partnership agreements, when you act as an estate agent, have the right contracts, have the mandate, have your joint venture agreement, have your partnership agreement, have these things in writing, because otherwise we have to answer questions like this with a sad answer. Unfortunately, from where we're sitting, it might not look very good.
And I mean, that's so I suppose that's the confusion. So I'm trying to place it into context. So very likely there was an owner of a building, and maybe they had JV'd, or they had a partner that was also trying to assist with the building, and this client or this viewer approached this partner, and there were conversations, and they're now saying, but the two of them entered into an agreement, but this partner is a 10-year like partnership, or whatever the case is. The problem that you're going to experience is exactly what Silna says. So remember, earlier in the show we spoke about consensus and meeting of the minds. Whose minds exactly were being met here? Because a contract's not entered into, even if everyone thinks it's a great idea, and they're like, 3 parties are going, sure, yeah, no, sounds good. The reality is you have to have the intention to be legally bound, right, for a contract to come into place. Having a conversation, speaking of an idea, somebody going, you know what, that would be great. If you found tenants for that guy, that probably sounds like a brilliant idea. I'm sure that you could actually split the rent or sublet or whatever the case is. But if he's not entitled to buying that guy, and you didn't have a conversation directly with that guy, it's a problem. So you need to, who represented that they had the authority to act? Who did you communicate with, even via email? Who was the person? How did they represent the authority? And if you've got enough to say, but they represent the authority in that instance, even if you're not entitled to a portion of the rent because the person actually collecting the rent never had an agreement with you, there is now a question of damages, because this person who misrepresented, who entered into this false agreement with you and caused you to do work and you get no pay for it, you'd be able to sue them for damages. But then you need to prove that they did something wrong and that they represented that they had the authority. If no one had the authority and no one represented that they did, it's going to be an uphill battle. He says, she says, oh, but when we spoke, you said this, and those trials never go down well.
No, and it's costly with low prospects of success.
Yeah.
I think that was that, Bruno.
Yeah.
Now you can finally break your fast. I'm
Thank
sorry I kept you hungry for half an hour over time.
It's fine. This happens all the time.
Are you angry yet?
It's gonna get there.
Okay, so let's say bye before Bruno gets angry. Thank you guys for joining us. It was a much longer show than usually, but finally, Bruno, we got through all the questions we received from December and Jan. So well done. I'm very impressed. We are actually up to date with the questions, guys. Now that we're up to date with the questions, please keep them coming. Otherwise, we have to, sit and look bored on a Wednesday. So please keep those questions coming. All righty. Have a good one.
Thanks so much. Thanks, everyone.